for this morning's proceedings. I extend a very warm welcome to the Caribbean Court of Justice. These are our housekeeping matters. Please mute your microphone, save and except when you are speaking. Please say your name and the name of the party you represent when you introduce yourselves. Please try as much as possible to minimize all background noises. Should you encounter any technical difficulties during these proceedings, we have catered for that by placing a chat on the sidebar with the name and telephone number of our IT staff who will ably assist you. This chat is available to all parties. We, however, advise that you do not send written messages to the chat, that you instead use the telephone number provided. During these proceedings, as per usual, I call the name of each judge, and each judge responds. You do not respond to the judge's greeting until you introduce yourselves. Again, a very warm welcome. It's a pleasure to have you, and we shall start promptly at 10. Thank you.
Madam Deputy Registrar, could you open these proceedings?
Thank you, Mr. Justice Witt, Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Guyana, Case Management Conference in the Consolidated Appeals of GYCV number 1 of 2022 and GYCV number 2 of 2022 between the Attorney General and Monica Thomas and others, and Bharrat, Jagdeo and Monica Thomas and others. The members of the case management panel are Mr. Justice Witt, presiding judge.
Good morning, counsel.
Mr. Justice Anderson.
Good morning, counsel.
And Madam Justice Rajnath Lee.
Good morning, everyone.
May we have the appearances, please? Thank you.
May it please the court, Devendra Kissoon with Natasha Vera, Sanjeev Datadin, Kay Hackett, Rishi Das, all led by Douglas Mendez, Senior Counsel, for the appellant Bharrat Jagdeo in matter number 2022 of 2002, and for the respondent Bharrat Jagdeo in the matter 2022 to number 1.
Your Honor, if it pleases you, Nigel Hawk, appearing with Ms. Kissoon, State Solicitor, Ms. Lal, Principal Legal Advisor, Ms. Ramzan, State Counsel, and we are led by the Honorable Attorney General, Mr. Mawbir, and Adnan Lal, Senior Counsel. 40, appellant. Obliged.
Good morning, Your Honor. Good morning, my lords. In this matter, I, Keith Scotland, I'm led by Mr. John Jeremy, Mr. Senior Counsel, Mr. Boise Paul, Senior Counsel, Kemraj Ramjatan, Mr. Mayor Robertson, and Selvin Peters, and we appear on behalf of the respondents.
Are you appearing for all the respondents or certain respondents, Mr. Scotland?
My lord, we are appearing for the respondents that I'm just getting from Mr. From the first, second, I think, and third respondents, my lord. I'm just confirming that from Mr. Ford.
I think it must be for the first and the second respondent. Is that correct?
The first and second respondents, my lord.
Okay, great. Thank you.
Good morning, Your Honors. Kurt De Silva, Legal Officer to the Guyana Elections Commission, appearing on the invitation of the court on behalf of the current Chief Elections Officer.
Any further?
May it please Your Honors, I am Ganesh Hira and I appear for Vishnu Bandhu, the representative of the United Republican Party in both appeals. Thank you.
May it please the court. Good morning, Your Honors. I am Kashir Khan, and in association with Mohammed Khan, Ivan Alert, Kalesh Lokman, and Joshua Abdul, we appear for Shazam Ali, the representative of the Citizenship Initiative in the Consolidated Appeals.
May it please Your Honors, Kamal Ramkuran, representing Jonathan Yearwood, who is a representative of A New and United Guyana, 11th and 12th respondents.
May it please Your Honors, Timothy Jonas for Asher Kisun of the New Movement, the 7th respondent.
No further attorneys? Okay, thank you very much. This is a case management conference, so this is about practical matters, which we hope to solve with you in a practical manner. As you know, and as we see, there are a lot of respondents in this case, and two of the appellants are also respondents in each other's appeals. So that makes a possible complicated situation, but we are trying to best to make it as simple as possible. The first issue that we want to discuss with you, which is a kind of an uncertainty, or looked like an uncertainty, in the appeal of the Attorney General, the third respondent was Mr. Keith Lowenfield, the Chief Election Officer, while in the appeal of Mr. Jagdeo, the third respondent was the Chief Election Officer. Now, it was quite uncertain who exactly was the third respondent. So the registry invited a representative of the current Chief Election Officer to be at least present. But we have discussed this matter now amongst ourselves, and we think the most sensible is to consider the third representative, the third respondent, to be the Chief Election Officer. So that for good order, that the Chief Election Officer, in our view, is the third respondent, as Mr. Lowenfield is not in that function anymore. And so we consider the third respondent as it was indicated in the Jagdeo appeal. So that for clarity's sake. Then we get to the more practical issues. Both appellants filed a record of appeal, which is more or less the same, but slightly different with different page numbers and so on. We would like the appellants to file a joint record of appeal, so that once we get to discuss the case, and there are references to the record of appeal, that there will be one reference and not reference to two records of appeal. So lawyers, the attorneys for the appellants, we want to ask to file that joint record of appeal not later than the 7th of June. That's a week time. Would you be able and willing to do that? Mr. Kisoon?
Yes, Your Honor, we would be most pleased to do that.
And Mr. Hawk?
Yes, please, Your Honor. Obliged.
Okay, yeah. So that will make things a little easier when we have to go through that record. So then the first order will be that the appellant shall file and serve a joint record of appeal not later than the 7th of June, 2022. Then we got written submissions. We would want the appellants, because this is the sequence of a petition, election petition. And the general idea of election petition is that it will be dealt with expediency. And so we would like the appellants to file and serve their written submissions on or before the 14th of June. And we would like the respondents to serve and to file and serve their written submissions on or before the 28th of June. We do not think it is necessary at this point to serve reply submissions. So what we will do, we go straight into oral submissions. And the date that has come out for us, which is feasible, but I have to look at Justice Anderson because I don't know if that is convenient to him, but the date would be the 22nd of July that we will hear oral submissions. That would be at 10 o'clock. We would start at 10 o'clock. I will come back to the oral submissions. The written submissions shall not exceed a total of 10 pages, inclusive of footnotes with 1.5 line spacing typed in Times New Roman size font size 12. More specific, I cannot make it. 10 pages, which doesn't mean that you all have to write 10 pages, because this is a neat issue. And what we would want to see, and I think there can be some form of collaboration between, on the one side, the appellants, and on the other side, the respondents, to some collaboration in avoiding that we get repetitive submissions all over the place. That doesn't augur well for a practical and comprehensive treatment of the case. So we are certainly not saying that you have to all write submissions, but when you write them, not more than 10 pages. Coming back to the oral submissions, again, there we... Now, let me first ask if 10 pages would do. If there's anyone who has an objection and who says he needs more than 10 pages, let him speak now. But if not, and I think you're all capable and experienced lawyers, so you will know how to succinctly say everything that you have to say. But if you still need more than 10 pages, you have to let me know now, then we can see what we can do about that. If not, then that stands. Then,
Your Honor, I
yes.
wonder if it would be just out of an abundance of caution if you can say 15 pages.
Well, I would have to ask my colleagues. Justice Anderson?
I think the point you made earlier is key, President, and that is that, sorry, somebody's phone is going off. Yes, I think the previous point is key, which is to
encourage some degree of collaboration between members on each side, so that we would expect, therefore, that the appellants would, to the extent possible, collaborate. And it may be that if Mr. Mendez thinks it's necessary to do 15 pages, the other person on his side might do 5. So we'll still end up with approximately 10 pages each. I think the chair quite rightly is concerned about the proliferation of the same submissions, which I don't think would be helpful to anybody. So unless Mr. Mendez, you can come to that kind of agreement or arrangement, I would myself suggest that we try to stick to 10 pages, or in the worst case scenario, we could split the difference and say 12.
Well, we would accept 12, Your Honor. I wasn't necessarily suggesting that the other appellant would, or maybe we are the other appellant, would reduce our submissions in collaboration. We have separate cases and we approach the issues in a different way, and it would benefit the court to have different approaches to the same issues. But I was just saying 15 pages, judging from our experience in this case, because quite apart from the direct issue of the jurisdiction of the Court of Appeal, other issues concerning the jurisdiction of the full court also arose. So those may have to be addressed as well. So I was suggesting that 10 pages may not be enough to address all of the issues, but 15 pages are likely to be sufficient.
Well, thanks. Chair, in relation to that, as I said, I think Mr. Mendez may have conceded 12 pages. But the other point I wanted to make, sir, is that I can assure you that I am available on the 22nd of July at 10 a.m. And I imagine that some of what you said about collaboration as regards the written submissions may also apply to the oral submissions.
Yes, that I will come to that, but that is correct. Justice Ratchnadley, any ideas about the page numbers?
Thank you, Chair, and I agree wholly with my colleague, Justice Anderson. I would think that 12 pages would be more than adequate, especially for these well-seasoned, experienced attorneys that we have before us. I am very confident that they will get it done and get it done very well within that, page number. I'd have no problem with it. I'm well prepared to go along with it. Normally, Mr. Mendez, we stay with 10, even for much more complicated cases. So, I think 12 is more than adequate. Thank you, Chair.
Okay, well, I think I will follow that too. So 12 pages, that would be the maximum. And it's not the amount of words, but the force of your arguments that will do the job, I suppose. And that will count for all those that are before us. So let's see how far we get with those 12 pages.
Your Honor, on the question of the date of the hearing, unfortunately, I have another professional engagement on that date. Is there another date that is available?
Well, we really want to hear this case before the recess starts, and if we can,
is there any other date in that week that's available?
I have to check that. I think it would be not the 20th, not the 21st. I'm not sure 18 or 19 would be open. Is that?
Justice Witt, 18th or 19th, those dates are open for us, please, Judge. Thank you.
Okay. Well, so I have to look at my other colleagues. I think the 18th or 19th would be all right. So.
Fine, Chair.
Yeah. Okay. Now, so you tell me a date, and then I will ask the others if that is convenient for them. But whatever happens, that week we are going to hear this case. 18, 19 is good for you?
Either date is good for me. Thank you very much, Honor.
Is there anyone who has a difficulty with 18 or 19?
Or whoever
In the afternoon,
preference
please,
for
Your Honor.
18th or 19th.
No problem. Then we could go for the 19th.
Honors, Your Honors, my lords, I'm reaching out to Mr. Ford and Mr. Jeremy. They had confirmed the 22nd. I'm reaching out to them to see if they will confirm the 19th.
Okay.
Or the 18th.
Okay, well, while you're doing that, let me go on with the timing of the oral submissions. As you will understand, with so many respondents and so many lawyers, we have to organize this, and I think part of that organization is in your hands. We thought that it would be reasonable if the two appellants together get 60 minutes, so they have to divide 30 minutes each. We also thought that it would be reasonable to give the first two respondents, which were the petitioners, in total 60 minutes, and the other respondents, they would have something to divide, not very much, about 30 minutes to divide. We do not want repetitions of arguments, and how many arguments can there really be about this neat point of jurisdiction? Maybe a few sub-issues, but not that many. As I understand it, not all the respondents have really actively spoken in the courts below. So this is a suggestion that there will be a 30-minute for the other respondents if they can arrange some division of time amongst themselves. And then there would be a reply of the two appellants for 15 minutes together. So they should divide that. If there is any problem with this suggestion, then please speak up so that we can deal with it. Mr. Douglas and Mr. Hawk, together 60 minutes for the appellants. Would that do?
Yes, Your Honor.
Yes, please, Your Honor. Yes, please, Your Honor.
Okay, then 60 minutes for counsel for Thomas and Nurse. Mr. Scotland?
We will make it convenient, Your Honors, we will.
Okay, and of course now I only have 30 minutes to offer to all the others, unless you think that that would not be enough. Is there anyone who wants to say about that? One of the other respondents?
If I may, Your Honor, would
Sure.
it be possible for the court to allocate 45 minutes?
Yeah, that would be possible. If that gives a little more leeway, that is 15 minutes more, that doesn't really matter, I think.
I believe that we can juggle that time amongst the remaining respondents. It will give us a little bit more latitude, I think.
Okay, 45 minutes, that would be okay, I think.
Thank you.
So, and then reply for the two appellants together, 15 minutes. If you can all work with that, then we can certainly work with it. We need to hear now from Mr. Scotland about the date of the 9th.
I thought Mr. Mendez was.
Oh, sorry. Yeah.
I was just inquiring whether that was 15 minutes each for the reply or 15 minutes total.
Well, we were thinking in total, but if you think that we can make it 20 minutes, but usually a reply is very short anyway, but you have a lot of respondents maybe, yeah. So if you need a little more time.
20 minutes then, thank you very much.
20 minutes for total, so 10 minutes each. And it could be that one takes 50 minutes and the other 5, but you will all cooperate in a sensible way, we assume. Mr. Scotland.
I've spoken to Mr. Ford, who indicated his availability. I've just messaged Mr. Jeremy for the 19th. I'm seeing two blue ticks, so I'm just waiting on a response. But I know Mr. Ford, you honest, we will just have to make ourselves available.
Yes.
Mr. Ford is available, and I am not. I see Mr. Jeremy's instructing is at Alexander and Jeremy. I don't know if she can either nod the head to see if the 19th is. We will have to make it available and convenient, Your Honor. Because this is the CCJ.
Yes. So the 19th of July, that is a Tuesday, if I'm not mistaken.
Yes.
Let me see how many minutes do we have in total. 2 hours, 45 minutes, 3 hours and a little, 3 hours and a little more. We could start at 10. We could also start at 9:30.
I think 10 would be fine.
10.
If I may. Yeah.
10 would be fine.
Yeah. Okay. Yeah, but that will take us a little past 1 o'clock. Maybe we have a break somewhere, so it might be somewhere take us to 1:30. But that is all. That is all right. As I said, because we would want to try to hear this fully and don't wait too long with the decision. So that is those are the points that needed to be discussed at this point. Is there anything else, Mr. Douglas?
Nothing further, Your Honors. Thank you very much.
Okay. Mr. Hawke?
No, please, Your Honor.
Okay. Anyone else? I think we discussed all the points, but yes? No further questions or comments? I think
Scotland, you were saying something?
Sorry?
I thought Mr. Scotland was saying something, Chair.
Yeah.
My lady, I have sorted out the 19th, Mr. Jeremy. We will be ready. This is the Caribbean Court of Justice. We will be ready.
Great. That's how we want to work. So you will get a written order in the course of today or not later than tomorrow. But I will repeat what I have here. The appellants shall file and serve a joint record of appeal not later than the 7th of June. The appellants shall file and serve written submissions on or before the 14th of June. The respondents shall file and serve written submissions on or before the 28th of June. There will be no reply. The written submission shall not exceed a total of 10 pages, of 12 pages, inclusive of footnotes, etc. The hearing of this appeal will be held on Tuesday, the 19th of July at 10 o'clock in the morning by video conferencing pursuant to Part 82G of the Caribbean Court of Justice Appellate Jurisdiction Rules 2021. The oral submissions of the parties shall comply with the time limits and the order of presentation as set out before, from hereafter. The Attorney General and Counsel for the Attorney General and for Mr. Jagdeo, they have 30 minutes each, which they can divide, but in total they have 60 minutes to make their points. Counsel for Mr. Thomas and Ms. Nurse will have 60 minutes. That counsel for the other respondents, if they wish to speak, they have in total 45 minutes to be divided among themselves in the order that they want to speak. We leave that to you, but in total it will be 45 minutes. And then there will be a reply, if any, by the appellants. In total 20 minutes. They have in total 20 minutes. And those are the orders that are made today. Will be in writing soon, and you will all receive that. We also decided that that the third respondent is the chief election officer. So we take off the name of Lowenfeld, that was the chief election officer at the time of the petition, but it doesn't really make sense to keep him that name in. It's the chief election officer, who was also actually designated as the third respondent by Jagdeo, appellant Jagdeo. So that is it for today. So thank you all. I think we're on track to hear this case, and we will see you all on the 19th. Madam Deputy Registrar, can we close off?
Yes, we can, Judge. Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnath-Lee. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you.